Good morning. Today we're going to analyze the Benkharbouche and Janah versus Secretary of State for Foreign and Commonwealth Affairs. First, we're going to explain the background and a little bit of the context, but my partners will explain the content of it after. First, we have to say that this case is about two women. We have Janah and Fatima Benkharbouche, and we have to say that both are Moroccan nationals. First of all, we're going to talk about Janah. Janah was working and was arrested in Libya, although she was Moroccan. So, in Libya, she was contracted by the government of Libya to work for it. But then she was contracted for working on the embassy, so she moved to the UK. Exactly, she moved to London. And she entered with a domestic visa. Then we have Fatima, which was a Moroccan national also, as I said, and she was working for the Sudanese government in Iraq. She agreed to move also to London to work for the embassy for the Sudan government. And both were dismissed. We have to say that Janah was working there as a domestic service, like she was the cooker, she went shopping, she was serving meals, and for example, she was also the cleaner. And Fatima was contracted just as the housekeeper and the cooker of the embassy. Janah, in first place, was dismissed in 2012, and she brought a claim to the court for unfair dismissal, not paying the national minimum wage, breach of working times, harassment, and discrimination. So, after that, we have to say that Fatima brings almost the same claim to the court, but adding that she also said that they haven't paid her like the holidays, and she also said that there was a failure on unpaid wages, more or less like the national minimum wages. The first thing we have to say about this is that states are immune. So what is state immunity? We have to say that state immunity is a principle, customary law, and state cannot be sued before the court of another state without its consent. And we have to say also that, as you can see, they are Moroccan nationals, but they are working for foreign governments. So states have a free of appointment of employees and a free of appointment and freedom to dismiss. Because we have to remember that Janah and Fatima were dismissed. The first one in 2012, and the second one in 2010.
First, the European Convention on Human Rights, Article 5, about the right to freedom and security, said in the observation made by the European Court of Human Rights in the Al-Absani case, to explain this case, it says that the measure adopted by a high contracting party that reflect the generally recognized norm of public international law are within the margin of appreciation of a state which make in binding. This observation is repeated in both the subsequent cases, such as the Fogarty case that Blanca is going to talk about. In the case Al-Absani against the United Kingdom, is conclude that the application concerns an international rule of jus cogens, and such as the prohibition of torture, and confront the universal jurisdiction of the national courts to hear the relative demands to this absolute provision with the immunity of jurisdiction of the foreign state. There is not enough consensus on the application of the state immunities, a contract for the non-diplomatic personal employment of a foreign diplomatic mission to apply customary law. In this case, in order to apply the Article 6 of the Human Rights Convention, the national legislation must seek a solution that is not outside of the currently accepted international standards. They conclude that unless that international law requires the United Kingdom to treat Libya and Sudan as immune from the claims of Ms. Janah and Benkharbouche, the denial of access to the courts to resolve their claim violates Article 6 of the Convention on Human Rights. Well, the second one, United Nations Convention on Jurisdictional Immunities of the State and their property, in his Article 11 about the contracts of employment, said, unless otherwise agreed between the states concerned, a state cannot invoke immunity from jurisdiction before a court of another state which is otherwise competent in a proceeding which relates to a contract of employment between the states and an individual for work performed or to be performed in whole or in part in the territory of that other state. 3. Immunity Law of the State of 1978, Part 1, proceeded in the United Kingdom by or against other states. The law of the state immunity derives from international law, but the manners of its application in the UK is determined by the State Immunity Act 1978. Specifically, Section 1 of the Act established that the UK courts have no jurisdiction to adjudicate disputes against other states unless one of the exceptions described in the Act applies. In which types of transaction or proceeding do states not enjoy immunity from suit, even without the state's consent or waiver? How does the law of your country assess whether a transaction falls into one of these categories? The Section 3 to 11 of the Act established the following exception to state immunity, like the first one, commercial activities, and the second one, contracts of employment. Well, and the last one, the point 5 is report of the International Labor Law Commission, 53 period of sessions, 1991, unless the state concerned agree otherwise, no state may invoke immunity of jurisdiction in a court of another state in a proceeding concerning an employment contract between the state and natural person with respect to an execute work or thus be fully or partially executed in the territory of that other state.
So, as my partner Johan said, Article 6 of the European Convention of Human Rights has to be taken into consideration for this case resolution regarding to the state immunity. So what is the state immunity? State immunity is a mandatory rule of customary law which defines the limits of domestic court jurisdiction. Unlike diplomatic immunity, state immunity does not derive from the need to protect the integrity of foreign state governmental functions or the proper conduct of interstate relations. It derives from the sovereign equality of states. But in the modern law, the immunity does not extend to the acts of private law character. Nonetheless, the Strasbourg Court has dealt with many cases invoking the Article 6 of the European Human Rights Convention, such as the Fogarty's case. The Fogarty's case was a case that came to the Strasbourg Court involving a claim about a sexual harassment brought in England against the US by a secretary employed at the US Embassy in London. So in this case, the court said that the Article 6 was yes engaged but not violated, but also addressed a question specifically to the diplomatic employment disputes regarding if the state immunity does apply to all the members of the staff or just to the most senior members of the nation. Then, why is the violation of Article 6 invoking Ms. Janah and Ms. Benkharbouche claims? It is because of the State Immunity Act. This act confers immunity to the states in cases of employment claims by embassy employees. The State Immunity Act is a legal instrument in the UK which regulates the judicial proceedings between the United Kingdom and other states parties to the European Convention of State Immunity. Both states are immune in the UK because of the Articles 4.2b and 16.1a, which say that a state is immune as respects proceedings relating to a contract to the employment between a state and any person who at the time of the contract was not a British or non-resident in Britain. And a state is immune as respecting proceedings concerning to the employment of any members of the staff of a diplomatic mission. The key point here was that the supervision denied the access to the UK courts to Ms. Janah and Ms. Benkharbouche, so they didn't have a legitimate access to the UK judicial system. As in accordance with the UK law, national courts didn't have the obligation to judge in this case. As there was no consistent rule of international customary law about employment, the working group of the International Law Commission in 1999 observed that the application of the immunity would depend on the employee's functions which are performed in the exercise of the governmental authority or not. A governmental act is understood as a sovereign act of the state. So the employment of a diplomat, for example, would be a sovereign act, because diplomatic functions cannot be performed by any private individual, as they are state functions. By contrast, domestic staff functions can be performed by an individual. The question here is if Ms. Janah and Ms. Benkharbouche are entitled to immunity. First of all, the court must consider the whole context of the case and the relevant acts upon the claim is based. The court has to consider if the functions of Ms. Janah and Ms. Benkharbouche are subject of a sovereign act of the state or just subject to the private law. In the cases of employment, the court's resolution depends on the nature of the relationship of the parties. So the question here is, are Ms. Benkharbouche and Ms. Janah entitled to immunity? First of all, the court has to take into consideration if the employment act of Ms. Janah and Ms. Benkharbouche is a sovereign act of the state regarding to the application of the state act of immunity. These are the three elements that the court will have to be taken into consideration to reach a conclusion.
So another legal reasoning aspect that has to be taken into account is the restrictive doctrine that appears in the year of 1978 after two cases one case regarding Nigeria and the other case regarding the Philippines. So the restrictive doctrine understands that states are only immune in cases of act of sovereign authority exercise, iure impedi. It is never immune in cases of private law nature, iure gestonis. And the Act of 1978 of the UK says that all the states are immune from the jurisdiction of the courts in the UK, except in cases regarding to private law character, especially commercial transactions and commercial activities in general. And we can see that the restricting doctrine as a norm in the draft articles number 11 of the UN Convention of 1991 on jurisdictional immunities of states and their property. And this article reflects especially the domain of employment. And it says that the states are never immune regarding employment, except in 5 cases that the employee has been recruited to perform functions closely related to the exercise of governmental authority. Number 2, the subject of the proceeding in the recruiting, renewal of employment or reinstatement of an individual. The employee was neither a national nor an habitual resident of the state of the forum at the time when the contract of employment was concluded. Number 4, the employee is a national of the employer state at the time when the proceeding is instituted, or number 5 and last one, the employer state and the employee have agreed otherwise in writing. And these draft articles, even though they are draft articles, they are understood by the international community as customary law because that is a sustainable conduct of the majority of states regarding this norm. The first time that the question of state immunity was raised in the UK was during the Shaki case. And the Shaki case was about a coalition action brought against a ship which belonged to the Caliph of Egypt and flew under Ottoman Imperial flag. But it was being used for commercial purposes under the charter of the British Trading House, and the court in the United Kingdom decided that it was clear that the ship had no immunity because it was being used for commercial purposes. And we will see that the restrictive doctrine based on the draft Article 11 as a customary law will be used in the resolution of the cases of Ms. Benkharbouche and Janah.
Hello, my name is Juliana and I'm going to explain the conclusions of the court. First, the court said that immunity does not cover every single aspect. It is only conferred upon acts which are an expression or an exercise of the sovereign authority of a state and not upon the private acts. The court also said that immunity is not attached to the employment in the local labor market. The court mentioned that even though there are other countries that have similar immunity act, it's not really a widespread representative and consistent practice of state, nor an accepted international obligation. Because of that, it cannot be considered customary international law. The consequence of this is that the State Immunity Act of 1978 is not justified by any binding principle of international law. The employment of Ms. Janah and Ms. Benkharbouche were clearly not exercises of sovereign authority, and nothing about their alleged treatment engaged the sovereign interest of their employees. Therefore, as a matter of customary international law, employers are not entitled to immunity. The court concludes that Section 4.2b and 16.1 of the States Immunity Act are incompatible with Article 6 of the Human Rights Convention. I also said that Article 4.2b and 16.1a of the States Immunity Act of 1978 unquestionably discriminates on grounds of nationality. The court pointed out that the scope of Article 47 of the EU Charter is not identical to that of Article 6 of the Human Rights Convention, but in this particular case, the violation of the Charter means that the Convention of the Human Rights is as well violated. In summary, the court concluded that immunity does not cover every aspect. For instance, in the Vienna Convention on Diplomatic Relations, 3 categories of employees in diplomatic missions were established in Article 1 and 3. The first category are the diplomatic agents. The second category are the administrative and technical staff. And the third category are the staff in the domestic service of the diplomatic mission. States do not have immunity regarding private acts performed by domestic staff. Also, European Union law prevails in some aspects. For instance, the right for domestic staff to bring a case to a court prevails in this particular case.